Good morning, Chief Justice.
Good
Ladies
morning,
and gentlemen.
Judge Gyanda. You have applied for the position of Deputy Judge President for the KwaZulu-Natal Division of the High Court.
Yes.
Just remind us, for how long have you been a judge of that court?
This is my 16th year.
16th year. And how many years are you left with before retirement?
Well, if I'm to go to the full ripe age of retirement, I got 8 years.
8 years. So you still have a long time to stay in the division.
Yeah.
Yes. Now, tell me, what do you understand to be the key responsibilities of a leader of the High Court, such as you will be if appointed?
Well, to ensure a smooth running of the division, to ensure collegiality amongst the judges, to have their support, and to ensure that we all work together harmoniously to support the Judge President and ensuring that all the work in the division is promptly and expeditiously dealt with.
Yeah. Well, you've acted as a judge president of that division before, have you not?
Yes, I have.
I don't know about you, but my experience as a leader in the judiciary over the years has been it's one of the most difficult leadership roles to fulfill. You can't move the one from here to another place in case of difficulties. And the disciplinary process is very long. How have you equipped yourself to cope with the leadership challenges in the judiciary?
When problems have, when I have
And
encountered
of course,
problems,
taking into account the overemphasis of independence, some judges, quite often, they will remind you as if you don't know that we are independent here.
yes, the problems that I have faced when in the period that I acted as Judge President of the division, I found that the best way to deal with it was to understand the problem from the point of view of the judge who had raised the problem, and to see how best we could meet each other part of the way in ensuring that the problem is ameliorated or overcome.
Well, one of the challenges that emerged at some stage, I won't say when, from your division, I'm not saying everybody, but there was a problem that is comfort with the requirement that it be known how each judge is going about his or her work. For instance, wanting to know whether judgments are reserved, and if so, how many and for how long, wanting to know how long it takes to finalize cases and so on. There was a concern, if I'm not mistaken, part of the concern was we are not public servants here, we are judges. Is that still a problem? Is it no longer a problem? If it is still a problem, how will you deal with it?
It is a problem with one particular judge, but that judge's problem commenced with the fact that the judge's registrar had passed on, and that she hadn't been able to get a full-time registrar employed, with the result that the typing, in our division, our registrars do our typing. We don't have a typing pool. The typing backed up, and her judgments were not delivered timeously. Yeah. And I found that when I was acting as Judge President, that I had to keep her out of court where I could, so that she could catch up with some of the judgments. And I think by now she must be almost there, caught up with her reserve judgments. And but you do get occasions where we receive complaints from members of the public and attorneys and even advocates that judgments have not been delivered in matters that have been long outstanding. And then when you speak to the judge concerned, it's usually delivered within a short time.
Yes. And very briefly, the constitutionally imposed responsibility to ensure that courts function properly or as efficiently as they should. How do you see yourself assisting the judge president to make that a reality?
That's a difficult,
In other words, Section 165(6).
yes. Mr. Chief Justice, in our division, the efficient running of the courts is hamstrung at present by the lack of capacity to deal with cases first of all, by the lack of the number of courts that are able to deal with matters accommodation-wise. And then we have had more recently difficulties with the recording equipment that's continuously breaking down, and manpower in the courts, the lack of court ushers to assist in the smooth running of the court recently. And then we have had strikes and protest action, which results in the workforce not being able to come to court at all on some occasions and being delayed and delaying the court process. But those are the main challenges we have had in dealing with the smooth running of the courts.
And, well, let me leave this for last. Maybe the judge president will deal with it. JP?
Good morning, Chief Justice. Morning, ladies and gentlemen. I'd like to continue on something which the Chief Justice had already raised. And it is this. There still is, to an extent, a tension which arises from the norms and standards that judges are required to comply with, and a claim by the judges of judicial independence. They sometimes come across as if the judges themselves consider this to be contradictory. How would you manage that tension?
The best way is to, as I said at the outset, is to discuss the issue with the judge, which norms and standards that he or she finds it difficult to comply with in view of the fact that he or she finds it restricts or impedes his independence as a judge or impartiality, and then to try and reason with the judge to show him or her that really it does not, or it does, and then we have to meet halfway and decide how best to overcome the problem.
Well, the Deputy Judge President has to work together and with the Judge President. So it's important that the two share a common vision for the division. What do you see your vision for, what is your vision for the future for KwaZulu-Natal?
That we improve first of all, the facilities that we have to provide the judges and the public for the better accommodation and hearing of disputes. As I said to the Chief Justice, and as you are no doubt aware, that we have had these difficulties in regards to accommodation, the stenographers or the machinery of collapsing, court staff not being present, and the accommodation. If these are improved and we improve the number of judges that we have, and we would be able to deal with the work that has to be done by the division. The case flow management scheme implemented by the Chief Justice has really been a remarkable success, and the backlogs are not so bad as before. We seem to be managing much better. My vision is that we should have very little or no backlogs, and that the judges and the staff should work cordially as a team.
Now, you acted as the judge president during the first session last year. Could you tell us what were the main problems you as a person experienced while running the division for that period?
The problems that I experience are the same that I've already addressed to the Chief Justice. You get complaints from judges about lack of staff, support staff, lack of supply in material required for the daily functioning of the court. Those are the types of complaints that I had to deal with. I had one complaint where a judge was finding it difficult to go on session because the judge had a young family that had to be attended to, and I dealt with that as I thought best in the circumstances by giving that judge more duties in Durban and Pietermaritzburg as opposed to circuit, and I brought that to your attention. But those were the main problem areas that I had to deal with whilst I was acting as judge president.
It appears to me that you see the problems of the division as consisting, one, of infrastructure challenges, and two, interpersonal relationship between the senior judge and the junior judges. How would you rate your interpersonal relationship with the rest of the division?
Well, I get on exceptionally well with everybody in the division. There is nobody that I can think of that I've had a problem with on any occasion and at any level.
How important do you consider that to be for the efficient running of the division?
It's very important because people work better when they get along better.
Thank you, Chief Justice.
Thank you, Judge President. Premier?
Thank you very much, Chief Justice and colleagues in the panel. My first question is, it derives from your earlier answer, which to which you were, when you were responding to the question about efficiencies in the division. What in specific terms, apart from lack of staff, equipment, and other things, that you think will improve the effectiveness and the efficiency of the division?
Training, proper training of the judges before they are appointed permanently. That would help greatly. We had at one stage courses for aspirant judges. I don't know if they still have it, but I found that was essential to the well-rounded training of a judge before they become permanent judges, or even before they start acting. And training, as we all know, is an ongoing process because nobody knows everything and we learn every day. So the seminars that are organized by the Chief Justice and his department are essential for maintaining well-trained judiciary.
Thank you very much. The next question is that historically, KZN has always been under-resourced with regard to just the number, a simple issue, the number of judges compared to other provinces and populations there. And this has gone on for quite a long time, including in the new era after 1994. And if you get appointed as Deputy Chief Justice, what would be your role in turning the situation around? Because more and more it's affecting people and it's affecting the administration of justice in the province.
Really, it is something that the Judge President and the Deputy will have to work together with in trying to convince the Chief Justice and the powers that be that when a comparison is done to the population in KwaZulu-Natal as against the number of judges available in the division, and if you compare it to the other divisions, we are under-resourced. And we have been under-resourced, as you said, for a long time. I remember Judge Shabalala was trying almost forever to get additional judges because we were short-staffed. Judge Patel was also, Judge Msimang was also trying to do that, Judge Patel as well. And I know from discussions with our current Judge President that he also has been trying to get additional judges. But you can't just get additional judges. We don't have sufficient accommodation. In Pietermaritzburg, chamber-wise, to accommodate the judge, we don't have space. And court-wise, we don't have space, both in Pietermaritzburg and Durban. I believe with the proposed extension to the Durban High Court and the renovations which are due to commence, it might alleviate the problem somewhat. But until then, there's not going to be space for additional judges to cope with the disproportionate number of people in the province as compared to the number of judges that have been appointed.
So it seems to me that apart from what you were saying about training and every other thing, even if you were to do those that you were counting, and even if issues of staff were to be solved or to be resolved, as long as these problems of short staffing and lack of accommodation exist, we cannot reach the kind of efficiencies and effectiveness that you were talking about.
Well, we've been trying over the years. For example, we used to use the Scottborough Court as an extension to the Durban High Court. So a judge would have to go and sit there. And we used the Pinetown Court as well. But that had also had some difficulties that ended up in the Supreme Court of Appeal about the manner in which the judges' staff and the assessors were accommodated there. So if and when the need arises, and we are short of accommodation in courts and chambers, we have had resort to going out, as I said, to Scottborough and to Pinetown, and on occasions even to the Durban Magistrates Court, when they have space to accommodate us.
How strong do you feel about this?
Very strongly, because the sooner we get up to speed with all these things, the quicker the work would be done, and the more comfortable all the judges will feel, knowing that they're not going to be overloaded in a session, that they could then dedicate the proper amount of time to their cases rather than feeling overworked at all times.
What I see, CV, you seem to have played some role on transformation. What, in short, has been your role in transformation, and what do you think going forward should be the main features of the transformation process in the division?
Well, opportunities should be made available to everybody. Equal opportunities should be made available to everybody. And I found that the best way to assist in the transformation process was to assist people who required assistance during, when I was an advocate, during pupillage and during training as advocates, and then even when I was on the bench, encouraging people to come and sit as assessors, where you saw their ability to understand the task and to be able to make a positive input, and then encourage them to take up acting positions. Our JP would tell you, it's very hard to get people to take up acting positions. In this last session, we had to wait until, I think, the last week of the last session before we got the names of the acting judges for the next session, because it's just so hard to get people to make themselves available to come and act in the division. So that would, in my view, be the main point that we should drive home. We should encourage people to take up the opportunities, and we should make available to them the equal facilities so that they can have the training and understanding of what the job entails.
How would this exactly be achieved?
Well, it starts right from the beginning. Education in universities, then when they come to the bar, that they have, or the sidebar, that they have articles with a proper firm, that they, at the bar, that they are pupilled with an advocate that's qualified to train them. And then we have the input, which we used to have, I don't know if we still have, from NADEL and BLA, where they hold training courses for aspirant attorneys and advocates, where advocates and attorneys, qualified advocates and attorneys, take time to train these aspirant advocates and attorneys in the manner in which they're going to pursue their respective careers and how the work is done, etc. And then when they come to the bar, if we have a mentoring system where senior advocates then mentor the juniors. We had at one stage in Durban a system where a silk would make himself available for a month or 2 weeks in a month, where any junior who is doing a criminal trial found himself in difficulties and required a senior to assist him, the Bar Council would appoint this silk to go in to the case and assist and guide this junior with the case that he had. I don't know whether it's still done, but this was a great boon to the juniors, because they would be working with a skilled person who was senior counsel, who had the training and the experience, and would be able to learn how to cope with these difficult situations. These mentoring programs are very important. And even as a judge, the people that we get in touch with, the assessors that we use, etc., it's important for us to encourage them and to advise them as to how best to equip themselves to deal with the difficulties in their various aspects, whether they're attorneys or advocates or whether they're going to be judges.
Do you have any concern at all about the apparent masculinity of the division?
We try as much as we can to encourage females, because we want to achieve the balance. And it's been a pet program in our division, but our judge president will tell you how difficult it is to get people, whether it's male or females, to come onto the bench, to come take up acting appointments. And it's especially more difficult to get females. I don't know why. Our judge president made a joke at his hearing, and it went down badly, but it's really difficult to get females to buy in, to come and assess, to come and act.
With your experience, you should know why. Huh? Why exactly, in your own view?
I don't know. I just think that we've inculcated in them a feeling that this is a male-dominated profession, that they are somehow less than us. But hopefully that is changing. The females that are on our bench, they stand up. I mean, they're equal to everybody else, and they do their job, and they've been producing very well. Work, and it's encouraging. We have a fair amount of females on our bench. But maybe also that the younger generation of especially black females are getting into very lucrative practices and jobs that they are reluctant to give up to come to the bench. They find the bench is going to be stifling them economically. And that's why they're not coming.
My last question is, what is your feeling about access to justice, especially for rural people, both in the south and north of the province, northern parts of the province?
We should make every effort to ensure that everybody, wherever they may be living and however poor or wealthy they are, have proper access to justice. The one thing I haven't been seeing recently that I used to see when I was an advocate is the informa pauperis proceedings. Informa pauperis is different from legal aid. Legal aid, they have qualification standards. If you qualify for legal aid, you'd get it. If you don't, hard luck. You don't qualify, you don't get afforded legal aid representation for whatever reason. But informa pauperis, if you couldn't afford it, an advocate would certify that you couldn't afford the cost of the litigation, and the litigation would be conducted on your behalf by attorney and advocate free of charge. I haven't seen one of those for the last 15 years, I think. It used to be allocated on a roster basis by the registrar. I have never seen one for a very, very long time. I don't know why. Because it was an obligation of advocates and attorneys to do that. You don't only do work that you're getting paid for. Legal aid work you're getting paid for, although you're not getting paid a good, fat, handsome fee as you would on brief in a normal way. But then informa pauperis, you don't get paid at all. But it is a contribution to society. But that's seemed to have disappeared. I don't know why.
Thank you, Premier. Colleagues, as I get to you, you know our agreement. Only the JP and the Premier have the leeway. Let us just be more focused, remembering that it's a leadership position. Minister?
Thank you, Chief Justice. And, I would assume, Judge Gyanda, that given the repeat visits I have made to that division in response, in part, to some of the challenges you've alluded to, I would necessarily have to make follow-up questions on issues of accommodation, amongst others. Can you just give us more information as to what the state of the court was at the time when I first visited, and following the meetings that took place, what change, if any, has since occurred?
Mr. Minister, I must disappoint you by saying that the position with our courts changed very little since your visit. We had promises of things being done. After you left, there were rigorous cleaning of the premises that windows and the toilets. And within a couple of weeks, everything fell into the same rut that we're used to. Things are not working, things are broken in the toilets. The ceiling that you pointed out to me had fallen down. It's still the same. The damages that we've got is still the same. I mean, for a couple of days or weeks after you had visited, there was rigorous running around by members of staff, but then it just all came to a stop. We've got a toilet downstairs, the door doesn't close. Nobody's attending to it. The latch, the handle has come off, and it was used to be kept on the side of the sink, but that's disappeared as well.
What, in your opinion, explains why interventions of this nature do not stick, are not sustainable? Is there structural problems? What exactly, in your opinion, given your close relations with the administrative side of the court?
We report the matter. Whenever we have a problem, we report it to the person in charge of taking care of that matter. And then we'll get the stock response that it's being attended to. And then when you follow up, you say, well, look, this hasn't been done yet. What's happening? He says, well, it's been reported. I don't know what they've done. So I say, follow it up again. And then you get the other stock report that they don't have the budget to deal with it, or it's going to be attended to, and you're fobbed off. It is very frustrating, and I can understand how frustrated the Judge President gets when he is receiving all these complaints on a regular basis.
Let me put it slightly differently. We called the three different organizations together, Public Works, Justice, and the OCJ, given their respective roles in this regard. One would have expected that some level of coordination was sustained between them in order to sustain the continuous improvements that were necessary. What do you think, in your opinion, has been lacking in ensuring that that tripartite relationship is sustained for the betterment of the conditions at the court?
In Pietermaritzburg, they've recently employed a handyman who has done a tremendous job in attending to our day-to-day needs when things break down and need to be repaired. I think we need to employ one in Durban as well, so that we don't have to keep on running the gauntlet, moving from one level to the other to try and get things done. But by and large, the biggest complaint has been the lack of funds. If you talk about our court building, it's just the same. We get inundated with complaints by attorneys and advocates about the condition of the public toilets that they have to use. And I feel embarrassed that we are still getting these complaints. We've got now security staff that are not working beyond their normal hours because they don't get paid overtime, with the result that the cleaners are not let in early enough to take proper care of the building. By 11 o'clock, the attorneys and advocates are coming in and complaining about the condition of the toilets. I mean, things like this, the JP doesn't have to deal with, but he's forced to.
It seems as if I may have to move office. Okay.
Well, rest assured, Judge Gyanda, on Saturday we had a meeting, the National Efficiency Enhancement Committee. It's been public works, we're sorting it out, don't worry.
Thank you very much, Mr. Chief Justice.
Commissioner Helens and colleagues, remember, relevance.
Thank you, Chief Justice. Judge Gyanda, in your time when you acted as JP in KwaZulu-Natal, what was your worst case of reserved judgments in one of your judges, both as to duration and number of reserved judgments? And what did you do about that?
Well, I've spoken about the one case that where we had a judge that had a number of judgments that were reserved. I don't recall the exact number, and they had been reserved for a long time. And this judge had been in this position during the period of the presidency of Judge Patel, and during the period that I had been acting as Judge President, I then tried to arrange to keep the judge out of court as much as possible where I could, so that they could catch up. But
Judge-
I don't know the exact number or the extent of how long they were outstanding.
Can you
There
give
was
me-
one particular judge that had judgments outstanding for more than a year, but that was due to ill health.
Apart from the ill health, can you give me any idea of the number of judgments? And when you say long time, how long?
Commissioner Helens, allow me to interrupt you. Judge Gyanda, fortunately, you're a very experienced judge. If you were not, I wouldn't want to unsettle you. Just be direct so far as possible, and then there will be a follow-up if a longer explanation is called for, please.
Yes, thank you.
Thank you.
Well, the longest I think was 12 months, and that particular judge had been ill and acting out of the division.
Yeah, I wasn't asking about the ill health. Really, it seems to me that your response as JP was to go and talk to the judge, ease the judge's burden, and encourage the judge to do better. Is there nothing more severe or more direct or more impactful that one can do as a JP?
I can't see of anything in that
Are you empowered to
Regard.
report the matter to the Judicial Conduct Committee or threaten that?
well, you can threaten reporting. That's about the.
But did you?
But I find that if you tackle it the way I do, it gets done. If you threaten somebody who's already in a difficult position, you're not helping.
Thank you very much, Commissioner Helens. Commissioner Singh?
Thank you, Chief Justice. Thank you. Good morning, Justice Gyanda. I just want to follow up on the question of access to justice. I mean, it's always a problem. The Premier touched on it. KwaZulu-Natal is a vast province. Now, access to justice can be lack of finances, an ability for the poor to access justice like a rich person could do. It could be location, because the only three towns I've heard you mention are Durban, Pinetown, Pietermaritzburg, and Scottburgh. And yet there are other areas where people need to go to the High Court. Then the other area, through you, Chief Justice, is language, particularly in KwaZulu-Natal. Now, what can be done? We know these are challenges. What, in your view, can be done to ameliorate some of these kind of challenges that exist, that ordinary citizens have, that want access to justice?
You may be misconstruing my answer about in relation to the shortage of space, about us going out to Scottburgh and Pinetown. But our courts do go on circuit to Ramsgate, to Newcastle, to Mtinzini, to Matuba, and to Vryheid, and to areas like that on a number of occasions. We have circuits there, so the courts do go on circuit. The language problem has been dealt with adequately by the provision of properly qualified interpreters in court.
So you're saying to us that the interpreters in court are properly qualified in KwaZulu-Natal?
Yes.
The next question relates to the advocates and attorneys that you spoke about. You said 15 years ago there used to be a system where they assist free pro bono services,
Yeah.
and you don't know why that's not happening. Has there been any move to interact with the bar, interact with the attorney's profession, and find out exactly why this is not happening, and do something about it?
Not that I, not that I know of. I have canvassed to the senior counsel that appear before me, and from time to time, as to why these mentoring programs, for example, are not continued with. But the informal pauperous cases to which I've referred, I don't know whether it's ever been taken up with the bar and the sidebar.
But
During
lastly,
during the days of the separate, well, we still have a separate bar and sidebar, but previously the bar used to control that, the allocation of informal pauperous matters through the office of the Registrar of the High Court. But I think that with the equal empowerment of the sidebar, this has caused the problem with the informal pauperous matters.
finally, do you believe that more should be done? And what can you do? If you are appointed DJP, what can you do in that regard? Because it's a very important way for poor people to access justice if they get free service.
Well, we've got to convince the law societies and the bar councils to reinstate that service with the assistance of the Registrar of the High Court.
Thank you, Chief.
Thank you, Commissioner. Commissioner Ntlama?
Thank you, CJ. Good morning, colleagues. Good morning, Judge.
Good morning, ma'am.
Yes. In your response earlier, you said you will ensure collegiality in the division. The question is, what mechanism would you put in place to ensure that collegiality? And secondly, you made mention of the challenge relating to acting appointments. So what is your view regarding tapping into the academia to fill in the void? And the third one, since KwaZulu-Natal is very vast, what is your view regarding the infusion of traditional values in the interpretation of the Constitution? And the last question.
There
on
should only be
language.
3, please. There can't be so many.
Okay.
Thank you.
Do you mind repeating? I didn't write down because I didn't expect them to be so many in one go.
Okay. The first question is, what measures would you put in place to ensure collegiality in the division?
Yeah. Yes, well, in our division we have, every morning we have the judges' tea, where all the judges, or most of the judges, meet to have tea and we chat. On Thursdays we have what's called judges' lunch, where all the judges have lunch together and we have discussions even after lunch. And in our division, very often we get invited by judges to their homes for various celebrations, so we get on very well. And I'm quite happy with what is in place to ensure collegiality. More than that, we don't have the time because we're busy working. Your second question was?
Your opinion on the challenge of acting appointments, whether would you
Get
go?
access to academia.
Yeah.
You see, if the people at the academia were exposed to practice or to the court itself, then you could use people like that. But people who have total lack of court exposure, going to find it extremely difficult to take up an acting position. And that is why it's been a boon to the judiciary, the programs conducted by the Office of the Chief Justice in training aspirant judges. And what was your last question?
Thank you, Prof. Commissioner Ndoni?
Thank you, Chief Justice. Good morning, Judge.
Good morning, ma'am.
The position of a DJP is by and large an administrative role. What are your primary strengths as an administrator?
Sorry, I don't get that.
What are your primary strengths as an administrator? Because the position that you're applying for is by and large an administrative role.
Yes, I've been in private practice and I administered my practice by myself. I have been an administrator in the amateur soccer organization called the Durban Football Association, and I administered and managed a football club by myself. So I have experience with administration.
I'm looking at the primary strengths. What are those strengths that you acquired in your role as an administrator, both in your practice and in the soccer club?
It's to be on top of things at all times. You got to know what's happening and be able to take care of problems that arise.
What challenges are you looking for in the position that you're applying for?
Well, the challenges are those that I've already discussed.
No, I'm
or
talking
raised.
about the challenges that you are looking for, because when you want to go to a position, there's certain challenge, something challenging to you and your strength about the position. What are those challenges that you are looking for in assuming this position?
To be able to overcome those difficulties that we have in the division and to ensure that all of the judges are happily working at their posts.
Thank you, Chief Justice.
Thank you. No, I don't know if you have answered her. Look, one of the responsibilities of a judge president and a deputy judge president is to ensure not only that the High Court works well, but also the district court and the regional court. And we know that most of the problems that the judiciary has is at the magistrates court level. How are you going to deal with those? Very briefly.
The magistrates court interacts with the judge president at the local, at the PEEC meetings, and ideas are exchanged.
Maybe for the benefit of other commissioners, what is PEEC?
Is the provincial enhancement meetings that are held.
Efficiency Enhancement Committee.
Efficiency enhancement meetings that are held in the province. And difficulties are dealt with at that level. The regional president is there, and between the regional president and the judge president, they deal with issues relating to the difficulties in the division and how they would be best dealt with.
Commissioner Nokesi?
Thank you, Chief Justice. Good morning, Mr. Judge Gyanda.
Morning.
I was not present in the previous proceeding that you were present, but I have read through some of the questions that you have to deal with. In one of your responses in relation to the slow pace of delivery of judgments, you said more judges should be encouraged to do more extempore judgments as a solution to the slow delivery or non-delivery of judgments. Is that your strategy if you
Yes,
are appointed as a...
Yes, there are many judgments that can be delivered extempore, where the issues are not complex or involved, and there is no need then to write or reserve the judgment for a long period. You can reserve it overnight to the next day and be able to prepare a judgment and deliver it. But what's been happening is that certain judges reserve, as a matter of course, every judgment for a period of time. Now, if we encourage judges where the issues are simple and not complex to deliver the judgments quickly and extempore, either on the day when they finish the hearing or a day after, it will deal with the backlog and the fact that there are so many reserved judgments.
Would you agree with me that telling judges to give ex tempore judgments would be interfering with how they conduct their work?
No, you don't.
In view of the fact, I want you to comment after I finish. In view of the fact that there are norms and standards which have been set out by when judgments must be delivered, what is the process of the JP when judgments are not delivered?
Not a question of telling judges to give extempore judgments. It's a question of encouraging judges to deliver extempore judgments where the issues are not complex and where they can do it, to encourage it, rather than reserving it over a period of time. And it has a disadvantage when it's a simple issue. You reserve it, and then you have a problem recollecting, and then it takes a long time to produce the judgment.
Also, there is now these days encouragement for senior judges to mentor the junior or acting judges. I understand that there was a person somewhere acting in Pietermaritzburg who was criticized by other an acting judge who was not delivering judgments, who was arriving to court late and not taking the court serious, I would say, from your response here. But I do not get what your intervention was as an acting judge at that party, a judge president at that time.
See, I was in Pietermaritzburg at the time. The judge in charge of the Durban High Court was Judge Kruger, because he was the senior judge. He was the senior there. And he complained about a certain judge just adjourning matters willy-nilly for no reason. And he wanted to know how this person got appointed as an acting judge. It was not a question of me interceding and doing anything. I could not. And he had to ensure that the work was done by that judge.
Commissioner Didiza.
Thank you very much, CJ, and good morning, Judge Gyanda.
Morning, ma'am.
In your earlier answer to the Premier about how you deal with the issue of improving diversity in the division, particularly as it relates to gender, and in your answer you stated some of the things you do, but I would want to know from you whether you think it would add value to engage with the law profession in the division of, or in the province of KZN, and even working with others nationally, such as your BLA, NADEL, and other such structures, to ensure that through those engagements, you can have a possibility of encouraging people who may avail themselves for the acting positions, particularly to also address the gender dimension.
That is being done all the time, ma'am. That is being done all the time. And our Judge President does that, encouraging these organizations and the attorney's profession, as well as the advocate's profession, to make people available to come and act in the division.
But I'm asking you specifically if you were given an opportunity to actually serve in the capacity as DJP.
Well, I've been doing that even when I was not acting JP. I attend the various meetings of the organizations that invite us and communicate with the members there about the need for them to make themselves available as acting judges. There's one particular firm that I've been phoning so often and leaving messages for a person to return my call when I was looking for an acting judge, but there was just no response. As I say, some people are making too much money in practice to be concerned about coming to the bench.
The last question relates to the judgment you delivered on the matter between Lesua and eThekwini municipality versus eThekwini municipality that relates to the powers of the municipality in regulating on environmental matters. And in reading through the summary of the judgment, it became clear to me that we may still, even though 21 years into our democracy, struggling with the interpretation of the Constitution in respect of the powers of the national, provincial, as well as the local sphere. And in your judgment, you indicate that implicit to municipal planning and its role, the Constitution would have assumed that even the local level, which is the municipality, have a responsibility to protect the environment. Clearly, which is what the other party, who was a property owner, didn't think so. And I'm just wondering, having recognized that, do you think there is a need to continuously educate society, but also engage with the public sector, particularly the executive and the legislatures, for them to have a better appreciation of what are some of those tensions that the Constitution, that might be seen to be in the constitutional provisions about the powers and function of the various spheres of state or government?
It would be important to engage with others about exactly what the Constitution provides in this regard. But then we must also bear in mind that we cannot then go and impose on other structures what their beliefs are. We would be accused of contravening the separation of powers if we go and tell the executive about, we go and engage the executive about how these things are to be interpreted. I don't see this as the function of judges. We deliver a judgment, and it's there for the public to know.
Thank you, Commissioner Didiza. Judge Gyanda, you're excused. Oh, okay. Yes, Commissioner Ntsebeza, you didn't, I didn't note you.
Well, I think you couldn't see it. Follow-up question on Mr. Singh. What's your own proficiency in languages?
English is a language that I'm good at. Well, I think I'm good at. Zulu, I can understand a little bit, very little. I can't speak it. And my mother tongue, I can understand but can't speak it at all.
Afrikaans?
Afrikaans, I can read, understand, and write.
Now, other than
Because
just...
that was, I was forced to study at university.
Other than just relying on interpreters, and there have been disasters in having to do that, do you think that judges should be encouraged to acquire functional knowledge of at least one African language or a predominant African language in that division?
Yes, I agree.
Would
I agree. I see that it's even catered for as part of the university LLB degree. In KwaZulu-Natal, it's become customary for them, the students, to do Zulu. I suppose in the other provinces they do the dominant local language as well.
would you do anything about your judges if you were appointed to the position, making an effort or acquiring the use of an African language in the division?
Yeah, I bought the tapes to teach me to speak Zulu, but I've still been struggling with it for a long time.
Now, on circuit courts, another follow-up question on Mr. Singh. What is the allocation of judges to do circuit courts, against a perception, and you can take it that I've heard this perception, that senior judges do not get sent to circuit court and or white judges and or Indian judges do not get sent to second court? Must I disabuse my mind of that perception?
Yes, in our division, I think you must disabuse your mind of that. I like going on circuit, and my JP has asked me, well, where would I like to go on circuit, and I tell him. At least in each session, I like to go on circuit because it helps me to catch up with any work that offer, like reserve judgments. And I'm sure it helps the other judges too. And I've not come across a judge in our division refusing to go on circuit. There has been a tendency to keep the most senior judges at either Pietermaritzburg or Durban so that other judges who have difficulties can approach them.
So the perception is not out of place.
Sorry?
The perception that senior judges do not get set to circuit is not misplaced on your testimony now.
No. Senior judges do go on circuit, but not as much as the other judges.
See. Last question.
That's the fourth now.
I was not aware we were restricted to 3.
Well, we agreed that we're going to manage time tightly, and the many questions that we ask, you may ask it, but we agreed to that I'm going to hold tight reins on all of us, and nobody should feel embarrassed when we do that.
No, I'm not feeling embarrassed, Judge President. It takes a lot to cause me to be. Now, the AFT has made this remark, and I see we have been skating around it. One of the remarks they make, and they recommend you incidentally, is that Judge Gyanda is an Indian male, the division is headed by a colored male. Is that something we should take into account? If so, why? If not so, why? Why not?
I don't think it matters what race the person is. As I said previously, we are now more than 21 years into our democracy. We shouldn't be concerned about racial quotas. I don't know why they said Indian male and why they referred to the judge president as a colored male. I thought the judge president was more Indian than an Indian male because all his friends are Indians, or most of his friends are Indians. Most people regard him as Indian in our community. Race shouldn't play a role in the appointment of anybody.
You are excused, Judge Gyanda.
Thank you, Mr. Chief Justice.